Okay, so this is chat session 2 for October 11th, 2016. And this chat session is really going to be dealing with what our main tool is in legal research is case law. And probably if you've noticed from what we've discussed in the past, since we're a common law jurisdiction, case law is very, very important for interpreting and understanding statutes. And pretty much if there's no statute in place, case law is what creates the law. So we've talked about those concepts before, but now we have to look at what exactly case law is. But before I get there, I want to just tell you guys good luck, good work so far. You're keeping up with the quizzes and the discussion board. It's important to stay engaged in this class because although it's a little bit different, it's about skills, and so you have to stay on top of them. You need the information in order to do the research, and so staying on top of the course is really, really important. So I really enjoyed reading the discussion board posts, and I thought that most of you did a really good job. And let me just say that the better organized they are and the more responsive they are to answering the questions asked, the better reaction I'll have to them. So make sure when you're answering them that you're adequately giving a response to the questions asked, because those questions are very, very key. So don't just give me one line. Show me that you thought about the question, organized it, before you actually submitted it. Okay, so today we're going to talk a little bit about case law analysis and case law review, finally tips for reading cases, and then we're going to talk about briefing cases. There's also a template of a case brief that's been posted that you can take a look at. And then Module 4, you're going to really deal with what you have learned. And both of the quiz and discussion board posts deal with a little bit more about how you work with cases, and that's kind of what we're doing. So I'm introducing cases to you, and in the next module you're going to figure out, okay, how am I going to work with these cases? So basically case law, and this is adopted from somebody else, cases, we've already talked about this. This is review. It's decided by the judicial branch, and what's most important for our purposes is that courts construe the meaning of common law, and then they interpret the meanings of statutory regulatory provisions. So we've got two parts. A lot of our cases are dealing with constitutional law, which is also a framework for all laws. All laws have to fit within the bounds of the Constitution, and if they're not, they're declared unconstitutional. What some of you have already noticed is that jurisdiction is important. So when we're looking at case law, we have to not only just look at what the case is, but what jurisdiction it's from. And that comes into play a lot of different ways. What I have here is both the U.S. and the state system. We've discussed before that it's a dual system. So there's 50 state court systems, and then there's a federal court system divided into circuits. And there are 13 circuits, and we talked about that before as well. Stare decisis, which means technically let the decision stand. It's the principle that courts use to adhere to previous precedent on topic. But the important thing is that courts of one jurisdiction are not bound to follow the decisions of another. Now, even though they're not bound, they often consult them for guidance as to what to do if there's no existing law within their jurisdiction. So that's another thing to keep important. There's binding authority, and then there's persuasive authority. Persuasive authority is sometimes primary authority from a jurisdiction that whose court does not govern in a particular area. Okay, so there's other considerations in terms of looking at courts. The level of the court is important. So decisions from a Supreme Court are going to outweigh a decision from a lower court, like a trial court or an intermediate appellate court. So the highest court is going to basically, it's going to outweigh the lower court decisions, particularly to the extent that they're contrary. The higher court view is going to govern. Newer decisions outweigh older decisions. So if there's an older decision, say a decision from 1886, if you have a 2006 decision, chances are the 2006 decision is going to be more relevant. Published decisions outweigh unpublished decisions. This is one of the areas of law that's rapidly changing with electronic research, but for the most part, a decision that's considered to be published, meaning that it is part of a reporter that we're going to talk about later, is considered to have precedential value in most jurisdictions. As I said, that's under evolution because with digital media, now more and more courts are taking into consideration what's called unpublished opinions that are available either on LexisNexis or online. Sometimes courts now publish their own opinions. And the final thing is the U.S. Supreme Court trumps it all. So whatever the Supreme Court does goes. And sometimes affectionately we lawyers call them the Supremes. Okay, so there's a couple of things I want to say here. Again, every time I look at legal research, it is evolving. So where are court decisions published? First of all, there's the print reporters or decisions. Now, everything that's published online is based on the print version. The interesting thing, as I've mentioned, the digital versions are getting more and more cachet, and lawyers are relying on them much more than the print versions because the print versions take up a lot of space and they're also expensive, and you have to keep updating them. Okay, so let me go back to the right screen. Okay, so and basically the other thing is there's fee-based systems, which are Lexis, Westlaw, and other commercial databases. One that's up and coming is Bloomberg BNA, which is another one that's people are using, particularly for business. And then now the cool thing that I really love about legal research is that a lot of it you can do for free because the courts a lot of times have the decisions on their websites, and there's other free websites. So that's the neat thing about legal research is that in a lot of ways sometimes you can even begin online. Ultimately you'll probably have to go to a print or a fee-based publication, but a lot of this stuff is now publicly available to anyone. Okay, so the important thing that this is showing is that decisions of different courts are put in different reporters. So what's pointing here is the U.S. District Court. So could someone tell me what kind of court the U.S. District Courts are? Does anyone recall? And if you do, just raise your hand. Anthony, go ahead. Oh, the question is the U.S. District Courts. What type of courts is the U.S. District Court?
Okay, can you hear me now?
I can hear you now.
Okay, great. The U.S. District Courts, are those the courts that would serve on a, oh wait, this is the U.S. Would those be the state level courts?
Nope. Okay, let's go to Brittany. I'm sorry. Brittany, did you have an answer to that?
Yeah, the trial courts.
Okay, Brittany got it. So that's what I was looking for. It's a trial court. So the U.S. District Courts are the federal trial courts. So that's what we're looking for. So Anthony, thanks for participating, but that wasn't what I was looking for. All right. So at the trial court level, so if there's a court a case that's being tried, say you're going to sue someone, you're going to take them to federal court, you're going to take them to the local district court. Usually in these pyramids, you can tell what the trial courts are because they're the one with the most number of courts. So 94 judicial districts. And for example, Florida has southern, middle, and northern districts, which the district courts. All right, so all of the district court opinions are published in what's called the federal supplement, which is called FSUP. So FSUP stands for Federal Supplement. And so every time I see the FSUP citation, I know that it's a district court decision. And I can find that decision not only in the books, which are shown up in the corner, but I can also find them in Westlaw and Lexis Advance. Sometimes I can also find them online as well. Sometimes they're published online. But those are the main places I'm going to look. The book, Westlaw, or Lexis. Okay, so now we have the U.S. Circuit Court of Appeals. Anyone want to tell me what kind of court we got there? I think Brittany had your hand up from the last time. Oh, no, you raised your hand again. Go ahead.
I want to say the appeal courts on this. No.
Okay, no, you're right. You see, don't interpret
Okay.
silence as scorn. No.
Okay.
Yeah, you're right. They are the appellate courts. And yeah, Flavio's also got that, appeals from the U.S. District Court. And also, yes, they can also be panels, someone also mentioned. So again, there's 13 judicial circuits, and they hear cases on appeal from the district court. So let's go and find out a little bit more about where these are published. Now, decisions from the U.S. District Courts are going to be published in one of the following. The first one is the Federal Reporter. And I know that it's the Federal Reporter because the abbreviation is just this F period, which looks weird, but it's the Federal Reporter. Those are going to be also appearing in Westlaw and Lexis Advance, and you can search the cases either in their federal databases or, as we're going to talk about later, by citation. There's also this wonderful website that a lot of people use, which is Emory's Federal Court Finder, which has all of the federal cases listed on it. So that's a quick way to get a federal court case and not have to pay for Lexis and Nexis in order to take a look at it. So a lot of times law schools and other services have the cases that the federal cases. All right, so let me go to the next slide. I'm going to take a sip of tea because my throat is dry. Hold on. Okay, so everyone knows what the Supreme Court is, right? I don't have to ask questions about that. But I can ask you, does anyone know any fun or interesting facts about the Supreme Court that they would like to share at this moment? No? Okay, how many justices are currently serving on the Supreme Court? Anyone know that? Okay, oh, eight. Everyone's got it. Perfect, you're so smart. Yes, 8. There should be 9, but some folks in Washington decided that we don't need 9 at the moment, so there we go. Okay, so the federal courts for the Supreme Court decisions, they're published in both bound and loose leaf services. The loose leaf services are becoming less important because of the digital copies that are now available of all of these things, but the publications are, the first one is the United States Reports. That's the official reports, Supreme Court reporters, and those are, if you can see this picture right here, it's the one that says 535, that is the United States report. Then there's the Supreme Court Reporter, which is a Westlaw publication, which is right next to it, which is that 109B. That's the Supreme Court Reporter. And then there's the United States Reports Lawyers Edition, and that's the final one that we have here in this picture. So all of those are versions, places where you can find the same decisions. The Supreme Court Reporter and the United States Supreme Court Reports are what we call, they're done by publishers. They're not the official version, but they have annotations, so they provide research tools. And then finally, there's the U.S. Law Week, which is a Bloomberg publication, which basically has updates on Supreme Court decisions as they're published. And it looks like the binder version looks like what's in this corner right here. So those are the places where typically, if you're looking for Supreme Court decisions, you can find them in any of these publications. And also online. Yeah, last night, I don't know if anyone has seen Last Week with John Oliver, but there's a really funny YouTube video of the Supreme Court where he replaces the judges with dogs. It's really funny. Jenny got it. It's hilarious. So if you want a little bit of humor in the midst of your studying, I would look that up on YouTube. Okay, so here's a sequence of publication. For print, there's something called a slip opinion. If any of you have remembered any of the important decisions where, like, everyone's waiting, like I think they did this for the Obamacare decision where they're trying to figure out whether they're going to strike it down. All these reporters are waiting for what was known as the slip opinion. They were waiting for the slip opinion, which is that small little booklet of the opinion. So that's what they're waiting for. Then there's advanced sheets. Advanced sheets are basically sheets that are going to be put in with the bound copies. So if they're updating the bound copies, but they are kind of put together. And then there's the bound volume, which is those things I was showing you before. It's you put all of the cases together and they end up in one bound volume. And electronic, it's all simple. Whether it's a slip opinion, advanced sheet, or in part of a bound volume, it's going to be in the database. So there's two places. If you're looking for a very recent opinion, you can either get the slip opinion, the physical copy, or you can go straight to the database because usually they have them up very quickly, sometime within a couple of hours with really important decisions. But if not, sometimes within like 24 hours. As quickly as they can, they get them online. Okay, so a slip opinion, this just gives you some information. The clerk of the court basically, okay, what is this? Anthony's asking whether or not there's a vacancy or is it set for only 8? No, there is a vacancy. There should be 9 justices on the court. So there's 1 justice that is missing. So the problem with the 8 justices that most lawyers kind of know that if you have a tie, if it's a decision 4-4, the lower court decision stands. So having a majority one way or the other is important for dealing with what we call new and emerging law, splits in the circuits. It's important to have a full Supreme Court for that reason. So that's why a lot of people who are lawyers are going, hey, what's going on? Fix the Supreme Court. It's broken. Okay, so so the slip opinion, basically the clerk of the court, so they're actually law clerks, former law students who are working for the court, and they do a lot of the administrative work. The format is called a slip opinion. I don't know exactly why they call it a slip opinion other than that the sheets of paper are very, I don't know, they're kind of like newspaper. And each one of these is an individual case. Each slip opinion is for one case and one case only. Okay, and here's the advanced sheet. And so basically what this is showing you is that these are the advanced sheets for the United States Supreme Court reports, which is a Westlaw publication. And what they're doing is they're gathering all the slip opinions, putting them together, and ready to put them into the reporter. That's all it is. So they're gathering a bunch of them, and they're putting them together to put into a reporter eventually. Okay, and the bound volumes they look like this. They are permanent and final format, and they're arranged in roughly chronological order. Now, the interesting thing is a lot of these books, I'm really familiar with them because print was big when I was in law school, but they're becoming a lot less popular, as I mentioned, because they're expensive, they take up a lot of space, and all of these things can now be found on the computer. What's important from a legal perspective still, with the distinction between print and unpublished, is that if something is bound, it has certain precedential value. Okay, so state courts, again, we have the same thing in terms of publication, and decisions from various state courts can also be found in the same types of formats, the print and electronic. And there's a variety of reporters, and there's also regional reporters. So pretty much most states have their own individual reporters. Okay, Jenny, you have a question. And then somebody asked why roughly. Sometimes I don't look down. So you can also raise your hand. Sometimes that catches my opinion. So, okay, let's go to Jenny's question, and then we'll come back to Lee's. So, Jenny, what's your question, please?
So you were talking about how the precedent is for the newer opinions versus the older, but then if it's a bound one, would that mean that it's older? How does that precedent work?
Okay, so so that's an interesting question. If you have, for example, a newer unpublished decision, but an older bound decision, you'd have to actually look at the rules of the court to find out what the weight of that unpublished newer decision would be. But if it's a decision that will be published, it's treated as if it's already published, meaning that if it's a decision that's going to appear in a reporter, then it's going to have that value. All Supreme Court decisions are going to be reported. So there's no problem with Supreme Court decisions. The decisions that we're talking about and trying to figure out are the lower court decisions like appellate court decisions and trial court decisions. At the state level, often trial court decisions are not published. In a lot of states, they don't publish them. Some states, they just publish their appellate court decisions. So typically, if you're looking at the state court level, you're going to be looking at appellate court decisions. Does that answer your question, Jenny?
Yeah, it does. Thank you.
And Lee, you had a question. You said why roughly. What were you referring to there?
I was referring to the previous slide about the chronological order. I was thinking if decisions weren't necessarily in chronological order, wouldn't that create some problems? You said they're roughly in chronological order.
It doesn't really create any problems because we look for the cases by the page number and the volume number. So roughly means that typically speaking, earlier cases will appear on lower page numbers than later cases. It's roughly because it's not always organized by the exact date. And that has to do with how the publisher organizes them. But for the actual Supreme Court reporters, the official ones, they are going to probably be chronological to a large extent. So again, it varies from publication to publication and from court to court, depending on what cases are being heard. So that's the best that makes sense to you, Lee?
It does, thanks.
Okay, so this chart here is all the regional reporters in the United States. And so I'm just going to point out, I guess I'm going to another application. Hold on. I don't want to go there. I'm going to come back to the PowerPoint. Okay, we're back here. All right, you can see it again, right? Because it's paused for a second. I hope you can see it. Can you see the screen? Nope. Can you see this screen? Nope. All right, let's see what's going on. People can see yours. Oh, can you see my screen now? There it is. Okay. It decided to do something fun. All right, so what's going on here, and what happened when I clicked on this, and you can do this yourself, it took me to Westlaw website, and basically when I click on this, it shows me what's in the region. So if you look at the color, this is Florida, Alabama, Mississippi, Louisiana are all in the Southern Reporter. So if I'm looking for a Supreme Court case, say from Florida, if it's I'm going to probably will find it in the Southern Reporter. These green states are the Southeastern Reporter. These sort of dark, it looks like almost like navy blue, is called the Atlantic Reporter. These states in the middle here are New York, Ohio, Indiana, and also Massachusetts, or the Northeastern Reporter. And then kind of in this weird area here, Texas, Missouri, Arkansas, Tennessee, Kentucky are the Southwestern Reporter, which is not really in the Southwest, but all right. And then there's a Northwestern Reporter, which again is really not in the Northwest, but it includes Michigan, Wisconsin, all those things. So what are you saying the West region is showing? Jenny, what are you talking about?
Sorry, I was just saying what was showing because you had asked that earlier. What slide was showing for us?
Oh, good. Thank you. Thank you.
I'm sorry.
Right. No problem. But anyway, so here the Pacific is a huge area, as you can see. It goes all the way from Oklahoma and Kansas to Alaska and Hawaii, which are down in the bottom. So that's one of the bigger reporters. You're going to find a lot of cases there. In particular, California has a lot of cases in the Pacific Reporter. So that's the regional system. These are for state cases, mind you. You're not going to find federal cases in the regional reporters. you're only going to find state cases, so keep that in mind. Okay, so state courts, basically you can find them on Westlaw, in the appropriate state database, and also in Lexis, the same thing. There's also internet sites that provide decisions, FindLaw, and these other ones, Washburn, Rominger. So, and also the various state courts also will have their own websites with the decisions, like Florida Supreme Court will have its a website with its decisions, and etc. So the cool thing is these things are available online free of charge. The more difficult thing is figuring out which ones you want to look at, and that's where the research comes in. How is it determined that which state would be in which region? Well, Westlaw did that. Westlaw is located in Minnesota, and basically it's interesting. This system was established in the 1800s, so that's one of the reasons why this is such a huge area, because in the 1800s we weren't necessarily going out that far, or there wasn't much happening from a judicial point of view in that part of the country, and I don't think we even had Hawaii in our as part of our state system. So that's part of the reason why this is so huge. It's because of when it was constructed. And so Westlaw did it. That's who determined it. So we already talked about that. Okay, citations. Now I teach legal research and writing also to law schools, and this is the thing they hate the most, but it's the most important thing is a citation. So if you have a citation to a case, and with the citation to a case, it means the case name, but more importantly, it's the volume number, the reporter abbreviation, and the page number. If you have those three things, you can find a case in a book or on Lexis or Westlaw, and you can typically also find it on the internet as well. So if you take a case citation and you put it out there, you can find a case very, very quickly. So it's kind of like the case's address. If you want to know where the case lives, you have to know what the volume number, the reporter abbreviation, and the first page, and you can find the case. Okay, so here's an example, the citation. There's the volume number, 456, the abbreviation for the reporter. Does anyone know, you can tell, you know which reporter this is. This is for which court? Anyone want to tell me? Type it in below. Supreme Court, that's right, Jenny. So this is a Supreme Court reporter, and my screen just switched. There we go. So this is a Supreme Court reporter, and the decision is 19. So this tells me, if I go to volume 456 of the Supreme Court reporters, the United States reports, actually, and go to page 1, I will find this case, and that case was decided in 1990. You don't need the date of the decision to find the case, but the date of the decision can also be important based on what we talked about before. So why is the date important? Someone want to pipe up and tell me why it's important, or type it? Everyone's got it for precedent, right? So for precedential, that's spelled different than presidential, like the head of the country. But for precedential value, the more recent decisions, it's important to know. So this tells you really quickly when this decision's decided. This was only 26 years ago. Actually, no, 36 years ago. Jeez Louise, I cannot add. Okay, so what court? We know, you can tell by looking at it. We got U.S. We know, first of all, that it's a federal case. It's U.S., and we can also tell that it's from the Supreme Court. So that's the other thing. Citations will tell you where the case is from. Okay, so here's some tips for critically reading cases. It's adapted from this particular website, so if you want to take a look, you can also click on there, and that website has more information about critically reading cases. So when we get to a case, you have to be careful about how you read it. So the first thing is you have to understand why the heck this case is important. And you also have to make analytical judgments about it. What in this is significant for me to understand? And then you have to determine what information is needed to understand the text. So it's not, you're not just memorizing it, cases are tools of analysis. So what a case is, it's almost like a lens. It's a lens to view the world. So a particular case will show you a particular result because of the view that the case takes, tells you how you need to look at the facts. So when you understand the case, if you understand how that lens works, what it's doing, what facts is it highlighting? What facts is it minimizing? What facts change the outcome? All of those things are going to be important for cases. So that's why critical reading is important, to understand the lens created by case law. What's this court's view of the facts in the world? That's important. So if the abbreviation U.S. Is U.S., is there, wait, is that all federal cases are just, no, it's just Supreme Court. If you have U.S., it's just Supreme Court cases. That's it. If it's a U.S. Court of Appeals case, it's going to be in Federal Reporter. So it's going to have F period or F second or F third. That's basically a circuit court case. And if it's a trial court case in the federal courts, it's going to be the F supplement cases. So that's how I know. I can just tell by looking at them. And because I'm incredibly smart. Just kidding. Anyway. All right. The next step. Okay, what does second mean? Second means second edition. And we like, for some reason in law, we don't like the N in second, and we don't like the R in third. So we call second 2D and third is 3D. So we like to be special. Okay, so there's a couple of things to do for reading a case. The first thing is you need to figure out how to put a case in context. So you have to figure out what the case is about before you start reading it, because it could be about anything, right? So you want to get some clues. So a lot of times you pre-read a case. What we have to help you pre-read a case, especially in Westlaw, are what we call head notes, and there's also a synopsis, things that give you some clues about what the case is going to deal with. And then you're going to actively read the material, taking notes, looking at words and concepts for basic understanding. Now let me tell you, looking at the words is really important. When I first got to law school, we had this thing called Black's Law Dictionary, and now it's online, and I think we have links to the law dictionaries. When I didn't understand a term, I looked it up. You have to look it up. You can't just assume that you know what it means. It's part of learning the language of law. They have these weird archaic terms. Some of them are based on French, some are based on Latin, some are based on German. It's just this old archaic language, but you have to learn what those terms are because a lot of times they have important legal significance. Okay, and so once you understand the case, you're going to begin to question like, why did the court do that? What's the reason behind that one? Do I understand what they're talking about? Hypothesize. What if this one fact were changed? Would that change what the court did? Would that change what the court's outcome was? And then predict. Predict is when I have a new set of facts and I understand a past case, can I predict what a court would do with that case? So those 3 steps are crucial. If you can understand a case, you can do all of those things. Again, cases are tools. You're not just trying to memorize the case and say, you're trying to understand how to use the case. And that's the most important thing. You need to use the case, not just understand it. So that's why it's a little bit more than just reading it and knowing the words. It's like, now that I've read it, how could this case be used? And that's the harder part. Okay, so you're going to place the material in context, which means you can determine why the material is being read, what's the purpose, and for example, you can look at other parts of the reading material like table of contents, chapter headings, definitions for unknown words. Now for cases, you're going to be looking at, basically cases have several parts. The first part is usually something that summarizes the case, particularly what happened in the lower court. Then you're going to have, if you have head notes, those are summaries of the key points of law. Excuse me, I'm going to, clear my throat. Anyway, so the head notes are key points of law. And then after that, you're going to have the facts. the facts of the case. What happened? What happened particularly, usually since it's an appellate case, the facts have been determined, meaning that the trial court said, well, this is what happened or didn't happen. These are the things we considered in making our decision. And then after the facts come, the court begins to look at what principles of law are going to apply. It starts by laying out what those principles are, and then it explains how those principles either apply or don't apply. Okay, and so let me look at this question really quickly from the question is, in doing research, how does one avoid allowing their personal interpretation to cloud them from identifying the true logic and reasoning behind a case? Now that is an interesting question, because in terms of reading a case, you are the most important instrument, and all of us come with our biases and things that will distract us from the key points of the case. What's important is to try to understand the case from the court's perspective. If you try to step into the shoes of the court and say, what was the court looking at? What did the court decide was important? You try to see what they saw as being important, and once you can do that, you can begin to be a little bit more objective. Does that make sense to you? Okay, I muted myself because I didn't want to hear anything I had to say. Okay, so basically, here's a case, and this case you can tell who the parties are. We've got debtors and the plaintiff and the defendant. I can tell it's a bankruptcy case because look, bankruptcy number, hello. And then it's the United States Bankruptcy Court, which is a federal court, and it's in the District of Nevada. And actually, an interesting statistic and fact you can throw out at a cocktail party is that most of the federal court cases are bankruptcy cases. Yay, people losing money. All right, so then here's the background here. This kind of is what's known as a case synopsis. It gives you a little bit of what's going on here. Order to show cause was entered why Chapter 7 debtor's attorney should not be sanctioned for his alleged one-size-fits-all to bankruptcy practice, which probably means he did something pretty shady with bankruptcy, which is not nice because people are in dire need. And then the holdings, and then it says, here we have Bruce A. Markle, and this J means judge. So he held that. So it's telling me that this is what the judge held, and it continues from there. Okay, and so continuing here, we've got a couple of things. This is part of what's called the synopsis. So the judge found all of these things. So the attorney did not fulfill his professional duty of competence, attorney's unbundling of legal services to exclude representation, etc. Attorney did not perform reasonable investigation. Attorney has violated code. So all of these things are the judge's findings about that particular attorney in that lower court. Sorry, in this court. Sorry, and then it says so ordered, which means that appropriate action. It says appropriate sanction for attorney's misconduct was disgorgement of all fees, etc., and it says so order, so continue with that. Now these things that I mentioned here are, I've talked about before. These are what are called head notes, which is, that's what they call them. Just don't ask me why. They're called head notes. Now, this one that says one, attorney-client, and then bankruptcy. What this is telling me is that there's an issue in here which deals with attorney-client issues and also bankruptcy. And that's one of the first issues that the court addressed. And so this topic here, bankruptcy court has power and obligation to determine what services debtor's attorney must perform in order to be entitled to reasonable fee and inherent power to regulate the conduct of attorneys that practice before it. So this is the legal point. Now let me tell you something. This point that's right there was put in by a publisher. It's not technically part of the case. It is really not part of the case. It is a synopsis, or what we sometimes call these things when they appear in digest is a squib. Don't ask me why it's called that either, because it's what they call it, which gives the point of law that the court was deciding. So there's all this weird terminology that you don't need to know, but you do need to know what this part is about. And this part is really about basically the legal points. So these are 1, 2, 3, 4, 6 legal points. Most of them deal with attorney-client. So most of this is having to deal with the representation of the bankruptcy attorney. I think I went backwards. Okay. Okay, here we go. So after you do that, you're going to actively read the material. You're going to take notes. You're going to annotate, outline, highlight the rules, and you're going to focus on the content and the language, and you're going to use your dictionary. And here's some example of legal dictionaries in order to find some more information. The other thing is the head notes also help you understand what issues are before the court. So all of those numbered things will tell you what the issues are before the court. Okay, continue. Is everyone still following me? Everyone okay? No questions? Okay. So the next thing after you've gotten through some of the basic things is this is kind of the heart of what you're going to do. Question, evaluate, and hypothesize. So read the case aloud or read it in the way that you can best absorb it. Ask questions and respond to the analysis and opinion and language of the opinion. Why did the court use that particular analysis? So why did they use a particular approach for the problem? Do you agree with the court? Now this is where your personal opinion can come in. Like, I'm not sure I agree with why the court did that. Is something missing? Did the court not consider something? Did it decide to overlook something? And if so, why did they do that? What additional information would you like to know? What didn't the court discuss that you think might be relevant? And is there a reason why they didn't discuss it? And can you guess how the court might rule with a different set of facts? This is probably the most important part of this whole thing, is once you can get inside the court's head and step into their shoes and see the world through the lens of their opinion, you should be able to look at another set of facts and view it in a way similar to the way the court would view it. That's the hard part, is understanding how the court saw what it saw, and then you adopting that same lens and looking at another set of facts. That's what's hard. But once you evaluate the case and ask those questions, you should be able to do it. And as you're beginning to do this, it takes a long time, but when you get better, you can do this a lot more quickly. Okay, so the summary: practice pre-reading, practice active reading, brief and use template, and then you're going to read Gallagher versus City of Clayton using these. So when you read that case, start trying to figure out, skim through it first. Then figure out what the issues are the court's looking at, and then read through it one more time and see what the court said or didn't say, what they emphasized or didn't pay much attention to, and then see if you can understand what the court's thinking was. The other thing you can do is take a look at this video, how to read a case and understand what it means. It gives you some more insight into how to read a case. And now case briefing. So this is our second and final part. So after you've read the case or while you're reading the case, you should be summarizing it. That summary is called a brief. So basically it's taking notes, and there's a whole bunch of formats for this. They have essentially the same parts, and the parts are, the purpose of a case brief. You're going to focus on the more important aspects of the case. You're going to use active reading, meaning that you're not just going to copy parts of the case, because copying parts of the case is not good. Okay, so Jenny said, okay, what's NVM? Okay, when I teach students who have trouble, I tell them to read each topic sentence, and that's absolutely true. Oh, never mind. Thank you, millennials. I don't have any idea what that is. All right, I just say never mind. Okay, so yes, reading topic sentences are really important in reading cases because they'll help orient you all the time. So you're going to, for briefing a case, you're going to try to focus on the important aspects of a case. Active reading, that means sifting through to figure out what's important. And useful when you have more than one case because it's a tool by which you can compare and contrast cases. So, elements of a case brief. The first thing is the name of the case, duh. Then the citation, which is what we just discussed. And then the facts. Now the facts, that's something you can work on because you have to figure out what are the legally significant facts. And legally significant facts, you know, are those facts that if you change them, they would change the outcome of the case. Procedure. How did this case get to this court? What happened? Something happened in the trial court and somebody appealed for whatever reason. That's the procedure. And then now what does this court have to do? What are they supposed to do with this case? Are they supposed to decide something? Or what do they need to do? Then the issues. So these are the legal questions. Now typically with appellate court cases, you're dealing with questions of law because the trial courts decide the facts. If there's a problem with law and what law should apply, that's when it goes to the appellate courts. And so these issues are questions of law. What law should be applied? Holdings. That's usually the court's conclusions on the law. So they find, for example, in our cases that a smoking ban is constitutional or unconstitutional. That's a holding. And the reasoning rationale is why they found that result. So why they found it constitutional, for example, or why they found it unconstitutional, that would be the rationale. What about the statute or regulation is unconstitutional? And finally, the judgment of the ruling. The judgment of the ruling is usually saying that we are going to affirm a lower court's decision or reverse a lower court's decision. It basically says it's the answer to the procedure, whatever happened procedurally, what's going to go on next. And then there's concurrent dissent. Now, judges don't always agree. If they came to the same result but for different reasons, it's called a concurrence. If they came to a different result, it's called a dissent. That's basically it. Hopefully that makes sense. I was going to say if it doesn't, too bad. Just kidding. All right. Let's move on. All right, so the name of the case, you're going to identify each party by name, and this is a famous case, I'm sure. And how do you know who the plaintiff or defendant is, appellant or appellee? A lot of times you have to go back and look at the procedure to see who actually brought the suit, because who's actually appealing may not be the plaintiff, for example. It could be the defendant because they lost. So you have to see who's who and look at the procedure to figure out how these parties started and why they're in these, why they are who they are at this point. Okay, so here's a citation, the reporter citation. So going back, it has the information that you need to look it up. We said that, and determines how much weight to give to the case. So we've got the U.S., it's the Supreme Court, and it's 1973. So 1973 is a while ago. I'm sure there's more recent cases dealing with the topic of abortion. You know that there are. Can someone hear me? Are there audio problems?
No, you're fine. We hear you.
Oh, good. Okay. Okay, great. And so those are the three things. In the citation of a case, you can immediately tell court, where to find the case, and when it was decided. Okay, so what facts do you include? Substantive facts, which are kind of background facts, who the person is, where they're from. Legally relevant facts, so facts important to a court in deciding, facts that explain what brought the parties to dispute. So those are facts or procedural facts. So the second one, facts that are important to the case. Like, as I said, those are facts that the court uses to make its decision. Again, those things are not going to be readily apparent to you. You have to sometimes go through the case to really figure out which are the most important facts. Procedures for a question: who is suing whom? For what? Why did they sue them? And what was the decision of each lower court? And who appealed? Those are the main questions you have to figure out. Sometimes you have to do a little digging to figure that out, but you should ask yourself that question. How did it get to this court? Okay, the legal questions. The court must decide whether did the court err? And usually when they're talking about the court, they're talking about a lower court, either the trial court or an intermediate appellate court. Did they err? And these issues can be narrow or broad depending on how the court frames the issue. So how the court talks about the issue is how they frame it. They can frame it very broadly or narrowly depending on where there's a question about what the law is. So if it's a newer area of law, it's probably pretty broad. If it's a well-established area of law, it tends to be narrow and trying to sort of tweak the law and make it work better. Okay? Is everyone okay? Because we are going a little bit long. Well, actually, we're still within an hour. Anthony's fallen asleep. Great. Anyway. All right, so the whole thing is basically the court's decision. It's how they're resolving the case. It answers the issue. It usually starts with yes or no. So yes, the law is constitutional, or no, the law is not unconstitutional. That would be a typical reason. And it can be broad or narrow. It can look at, no, this particular aspect of the law is not constitutional. It can be really broad or really narrow. It could be the whole law, or it can be a particular clause of the law. It's, you know, it varies depending on what the court's looking at and what they need to decide. So again, you have to read through the case to figure out what the heck is going on and figure out how to talk about the holding. All right, so the rationale, basically the basis, why did the court decide what it decided? The statute, if they're applying statutes, are precedent, policy. Dicta is when the court starts talking about stuff that's not in the case and just says, hey, if it were this way, this is how we would decide. It's interesting. It's not binding, but sometimes it helps you understand why they did what they did. So the basis, a lot of times we talk about the various standards of review, the rational basis tests and stuff like that for constitutional law. That can be the basis. Sorry, let me go back. Statutes can also be a reason for them if they're applying the statute. That can be the reasoning. If they're deciding whether to apply the statute, that's another thing. Precedent, what do previous cases say about this particular issue? And then policy. Policy is when there's no cases or statutes, but there's a really good reason to make a decision one way or the other. That usually it's what we call public policy. There's some principle that needs to be upheld, guarded, or protected. That's what policy is about. Okay, so the final thing is the judgment. Reverse means we're reversing the lower court's decision. Affirming, we are affirming the lower court's decision. Then there's denied, meaning that somebody's asking for the court to do something and the court is saying, I'm not going to do it. So they deny whatever that motion was. The other thing, the writ of certiorari, most of the times if you're going to a Supreme Court, you got to ask them. The British, they say, by leave of the court. We call it a writ of certiorari. And the court can say, nah, we don't want to hear it. So they'll deny it. Or they'll say, sure, we'll listen to what you got to say. Then that's when they grant it. They don't quite say it like that, but you know what I mean. All right. So the concurrence of dissent. Sometimes people concur or dissent without telling you why, and so you just kind of have to say, okay, they concurred, meaning concurs means I agree with the result, but for different reasons. If it's important enough, they're going to write an opinion. and explain why they concurred, meaning why did they want the same result but applying the law differently. Dissenting is, you know, these guys got it wrong and I would have reached a different result, but they outnumber me, so I lose, they win. There you go. That's how it is. Scalia. Yeah, Scalia did some dissenting opinions, but he also did majority opinions too, so, you know, that's how it goes. I'm channeling Scalia. Oh my gosh, what's happened to me? All right, let's move on. Finally, there's also a sample brief for illustration purposes. It's under, to go ahead and take a look at the case briefing PowerPoint, which goes through in a little bit more detail what I talked about in terms of the case brief. Bottom line is, you got to try it in order to learn how to do it. There's no other way than to just go through the cases, get a headache, not understand them, and then try to figure out what you're doing. So you have to work with the cases to make it all happen. So that's the end of the presentation. Are there any questions about cases, case briefing, the course, or anything that I can answer? Don't ask me philosophical questions about the universe. That is not why I'm here. Nope, everyone's okay? Oh, you completed the case study for, okay, I did get that, Flavio. The university is up and running. It's almost run away at this point. Okay, everything's clear, good. Yeah, definitely give yourself some time to read the cases and to understand them. Don't think you can read them as fast as any other thing. I remember when I was in law school, literally it would take me 10 minutes to read a page. So I would have to go over the case over and over to begin to understand it. So it's not about intelligence or lack of intelligence. It's about getting used to how courts talk about things and really beginning to understand what they mean. So give yourself some time to really look at the cases. And it is a lot of info. And so make sure you go through this PowerPoint again. Again, if you have any questions or something comes up later and you're like, you know, you said that really fast because you talk fast for some reason, can you break it down? I will. Feel free to email me or ask for clarification. I'd be happy to provide that. So any more questions? I'm scrolling down, so give me a second. Okay. Do I have any other tips for reading the cases? The most important thing, as I mentioned, is look at the procedure, look at the facts. As I said, those head notes that lay out the issues are really important. But the most important thing is to try to understand why the court did what it did. And I have to say, quite frankly, that U.S. courts are a lot more clear about it. I read a lot of British decisions, and after a while, it's very indirect, and it was hard to figure out what they're talking about because a lot of times they talk about what they're not doing as opposed to what they're doing. I think our court cases are a lot more clear because they're a lot more direct. So, yeah, try to figure out what the court is doing. You can disagree with it, that's fine, but try to understand why. The question that you must answer after reading the case is why. Why did the court do what it did? That's the most important thing to ask yourself. Okay? Any more questions? All right, so that's going to be it for tonight. You're going to get this posted as soon as I can pull it together. For some of you, I understand I need to put it on YouTube because you have other, I think it's because you have Apple computers. I might try to save it as MP4, but we'll see. I'll save it. I'll put it up. I will be in touch with you in 2 weeks. Otherwise, email me, contact me if you need something. Have a good evening.